Wonderful. We have, oh, James, as well, I want to welcome you this evening as we're starting to record. I keep forgetting those kinds of things. And we know that you're the parent of a special needs stepdaughter. And as you shared a lot of information with us the last time, it was really helpful because I think parents understand that you understand because this is a journey that you walk. You are an attorney, you're a court visitor, and I'd like to leave you with you talking about your philosophy. I think I could share it with people now because I have the opportunity to spend so much time with you in the fall, but I think it's important for them to know your philosophy. So I'll turn it over to you for you to introduce yourself.
All right. Before I do that, are we good at the school? Everybody's
Yes, they are on.
All right. So we'll go to slide number 2. Maybe we won't. Okay. Who is Jim? I'm not going to talk too much about myself, but what I kind of want to talk about to start with real quickly is my biases and my philosophy, because we all have biases here. One of the things that may sound very interesting is I'm a guardianship attorney, but I want to spend a lot of time educating people that a guardianship may not necessarily fit every person, and that is my bias. And this may sound completely different from anything anybody else has said, but if you have a profoundly disabled child who doesn't kind of ever leave the house or do anything like that, they may not need a guardianship. There may be other ways to manage things. So my bias is people maintain as many rights as they can. And I don't generally feel that a guardianship is just a automatic disabled child get a guardianship when they turn 18. So we'll start right there. Slide 3 is my disclaimer. I'm not going to get into that. This is not legal advice. So let's go to number 4. What is a guardianship? So what my focus on this presentation is guardianship for those with developmental disabilities. My personal opinion is that the guardianship law seems to be more biased towards elders in need of protection than maybe the situations we're dealing with every day. But all the rules and everything I'm going to talk to apply to all guardianships. So let's go to number 5. There are a few terms I'm going to start with, and the first one is respondent. That is the person of who the guardianship was filed against when the guardianship is pending. So when you file your guardianship pleading, they are not the defendant, they are the respondent, the individual who the appointment is being sought for. Once a guardian or conservator has been appointed, that individual becomes the individual subject to guardianship or the individual subject to conservatorship. Court visitor, I'll talk about in a little bit, but that's basically the court investigator, and we'll get into that in a little bit. And last but not least, there's a couple laws that it's worth knowing. There is the RCW. I talk a lot about RCWs. That's the Revised Code of Washington. That is our statutes, our laws. And then we also have this thing called the WAC. No, it's not that Jim is whack. It is the Washington Administrative Code. So what that is that's more where you'll find a lot of the deep down Medicaid stuff and things like that and some of the DDA. And before I go too far, I'm going to apologize if you hear clip-clopping of feet or you hear barking. That is just my dog, who is always upset anytime I am on a Zoom call, be it for friends or work, and my dog does not like it.
I'd like to remind everyone to please mute their mics right now if they possibly could, because we're hearing some background noise. Thank you.
Okay. So let's start with slide 6. What is a guardianship? So under Washington law, once an individual turns 18, they are presumed to be a competent adult and have all the rights that that entails. And that is a good thing. However, there may be some parties who are not actually able to undertake those rights, and that is when we start looking at guardianship. One thing, and this is slide 7, which we can look at, or we can just skip to 8. The pandemic screwed up all kind of time that I have, and I'm still not 100% sure where we are in the years. But our guardianship law change in 2022 was a pretty profound change. I still call it the new law. It's not really the new law. It's just the law at this point. That is RCW 11130, and it sets out all the requirements to appoint a guardian, to maintain a guardian, to dispute guardian actions. All those good things are under that. Now, what I want to look at, and it is slide 9 and 10, is what is very important to me is it is the intent of the legislature, and this is right in the statute. If you want to follow along at home, it's RCW 11130-001. It is the intent of the legislature to protect the liberty and autonomy of all people and enable them basically to live their best life, to use a term we hear a lot. Also related to that is that people with incapacity have unique abilities, and some people have the right to provide for their basic needs. So what I like to tell people is that just because you are different doesn't mean you need a guardianship. Just because you're eccentric doesn't mean you need a guardianship. And when you start looking at some of the things that have been used with some people, and some of the things that I have seen of reasons for guardianship, I once was involved in a guardianship proceeding where the petitioner thought we needed a guardianship because she went over to somebody's house and there was a frozen pizza box in their garbage. And that meant they were not getting good nutrition and they needed a guardianship, which is, of course, insane. That is not what the law is looking at. So, if we have to restrict somebody's liberty or autonomy, and this is slide 11, we have to do it to the minimum extent necessary to protect their health, safety, or adequately manage their finances. What that basically means, and we'll see this in a little bit, is we don't want to just say, my child has autism, they need a full guardianship and full conservator. The first problem there is a lot of our children with autism don't have any money. And I will talk in the future how we can provide for people who have some money. And I may just tack on a little bit at the end if we have some time to talk about ABLE accounts, but I will be presenting on those going forward. I think that might be the last of the presentations. But we want to make sure that we're not just taking away rights or keeping rights away willy-nilly. So now moving to number 12, a determination of incapacity is a legal, not a medical decision based upon a demonstration of the lack of ability to do things. And what I really like to look at is the second part of what this slide says. Again, this comes from the statute. Age, eccentricity, poverty, or a medical diagnosis alone are not sufficient to justify a finding of incapacity. So if you have a diagnosis of autism for your child, that alone does not mean they qualify for a guardianship. There's other factors that have to be looked at. So as I've said, my bias is having people live to the best of their ability, not kind of taking away their rights just because they have a disability. And one of the things I spend a lot of time doing is meeting with people to see if they have the ability to do what's called a lesser restrictive alternative. I'll get to that in a second. Where can they do a power of attorney? Can we do something like a other decision-making ability? Do you have somebody who is a rule follower? So if we lay out certain rules, they might actually follow them instead of taking away their rights. Moving to slide 13, when an individual has a significant risk of harm based on an inability to provide for nutrition, health, safety, that's when we have a guardianship. So when you have somebody who is living on the street because they don't understand that there are things available to them and say they got beat up at the shelter, that might be a demonstrated inability. Just because they have a disability and they're living with mom and dad at home and mom and dad are taking care of them, you might not need it. Now, just to confuse things, they changed a lot of our terminology, and I'm not going to bore you with the fact that I think court visitor is a terrible name. It sounds like I'm from outer space. They should have just called the court investigator, but nobody called me first. We also changed our term. We used to use guardian of the person and guardian of the estate. Now we use guardian, which is dealing with placement, day-to-day health, management of healthcare, things like that, and conservatorship, which is money. And my joke I will leave you is, if what you know about conservatorship you learned through Britney Spears, ignore all that. I don't know what the laws are in that state. I don't remember even where it was. That's not really how things operate here. And I don't know enough about that case, but it's hard to see how somebody who seemed somewhat together needed those kind of things going on. And in this presentation, I'm just going to use the term guardian when I mean guardian and conservator. So going to 15, when someone, because of a disability, cannot handle their own personal and or financial affairs, the power to make those decisions is removed and placed in a guardian. It must be result of disability. It's not just bad judgment. Court is the super guardian. I heard a judge kind of question that and not love that he was, but the court is always the guardian, and the court's job is to always look over. And it requires some demonstrated harm, though sometimes the court doesn't always look at that. So there is a three-pronged test to guardianship, and that is going to be 17, 18, and 19. So I'll start with 17. The respondent lacks the ability to meet essential requirements for their physical safety, physical health, self-care, because they're unable to receive and evaluate information, make or communicate decisions, even with technology support services or supported decision making. So what they're saying there is, there's some people who can speak with a voice box. Those are things that we need to look at for individuals. It's not just, hey, you can't talk, so therefore you have no rights. It's, is there any way to make people talk? And maybe this is aging me, but I always remember Stephen Hawking, who had kind of the robot voice to talk because his body would not allow to do that. He didn't need a guardianship. So that's prong number one. That's often the easiest prong to meet because often you have somebody who is disabled, but that's not the sole requirement. Then we go to 18. There is a appointment is necessary to prevent a significant risk of harm to the adult, physical health, safety, or self-care. So that's 2. That is the one that kind of gets thrown away sometimes, and one of the ones that I kind of harp on. And when I'm a court visitor, I ask, what is the significant risk here that we're worried about? And last but not least is the big change, and that's slide 19. The respondent's needs cannot be met by protective arrangements other than guardianship. There is no lesser restrictive alternative. What are lesser restrictive alternatives? Well, an option is a power of attorney. Just because you have a disability doesn't mean you can't execute a power of attorney. Just because you are nonverbal doesn't mean you can't execute a power of attorney. And I have executed power of attorneys for people who can communicate what they want, but sometimes it's kind of a different situation than it would be for those of you and I that can communicate well. And sometimes it's by pointing, sometimes it's by writing. So just because we have a disability doesn't mean that we can't do a lesser restrictive alternative. The other thing that exists are kind of what's called supported decision-making agreements. And this is an attempt for lawyers to be creative. And I think I had hinted a little bit earlier that sometimes some of our kids are very much rule followers. My daughter is more a schedule follower. In that if you promise something and it changes, that becomes a meltdown issue. So what I have seen and certainly heard talked about is supported decision-making agreements that say you will not do drugs, you will not hang out with Fred, you will not do this. And sometimes they actually work for certain people because they are just so ingrained to follow the rules. I think, and I can't really talk much about guardianship in my daughter because I'm too close to, or stepdaughter really, I'm too close to the situation, but I do think she has more capacity, even sometimes than I think her mom gives her credit for. And that is sometimes a frustrating situation because here am I in the law. Her mom is not a lawyer, but she is still convinced she needs a guardianship. Now, she's also 19 and has drug her feet. So that to me says there's no risk of harm here. But that's kind of where we are. Now, what does it mean to be a guardian? There are a lot of requirements. There are a lot of rules to follow. And quite honestly, when a lot of people do it on their own, which is called pro se in the legal world, I see a lot of screw ups. If you are exceptionally organized, you can do this, but for less organized people, it's sometimes very hard. I was a court visitor on a case, and I got an email just this week from somebody saying, "Hey, I know you can't help me, but I've got this review coming up. What paperwork do I have to get to?" And I'm like, "You got to your review? You never even did your plan and inventory." So they skipped a whole step there. The one thing is the court is pretty understanding of that. If it's not an attorney's not involved, they are not understanding at all when an attorney is involved. But you've got to remember there is somebody looking over your shoulder and you can get in trouble. This is not file a guardianship, get appointed, and forget about it. And that's something a lot of people really look at. So if we move to 21, it talks about some of the duties. A couple of them include you have to report to the court if there's any change in the person's condition or residence. So they move out of the house and move into a group home, you got to report that to the court. You also have to care and maintain the responding in a setting that gives them the most freedom that is appropriate for them. And I am learning a lot of things as I practice longer and longer. Apparently, you can lock an elder who has dementia in a lockdown unit, but you can't necessarily do that for other parties who have, maybe substance abuse or those other issues. I don't really understand that, but that's where we are. Also, one of the big things that guardians sometimes forget is as a guardian, you are not substituting your judgment. You are doing what the individual would do, and you are asserting the respondent's rights and best interests, not what you think is best. And I know that is a hard thing for a lot of parents because you've been used to promoting your values, and now you've got to look out you still have to look out what's best for your now adult child, but you can't say, well, you can't do that because I say so. I'm sure there are a few parents on this call who wishes you could get a guardianship just to revoke their screen time. Since my daughter has got a phone, I turn around and she's on her phone looking at screens when she has limited screen time. I would love to have that ability, but that's not something a guardian can do. Moving to 22, I already talked about you will not substitute your moral or religious values or opinions or philosophical beliefs for the individual. You will promote the self-determination of the adult and encourage the adult to participate in decisions. You have to handle their finances and basically you're what's called a fiduciary, which means you have to do what is in the individual's best interests. And you have to make decisions that the person would if they are competent. That, again, that shows how the law is focused more on elders because the elders were living a certain way. So if you had somebody who was a lifelong, atheist, and now their guardian is making them go to church, that doesn't sound like that's in their best interest. That sounds like there's some substitute judgment. But I do not see how that we can do that as well for our disabled children because we don't know what their wants, needs are sometimes, and sometimes the lack of communication is what's so frustrating. Now, moving to 23, conservators very similar, but there needs to be a significant risk of financial harm based upon a demonstrated inability to adequately provide for their finances. The conservator duties in 24, and I'm not going to read through everything because you can all read. You have to inventory the estate. You have to protect and preserve the estate. You have to invest and reinvest the assets. And it's not as specific as the old statute, but the tasks appear to be similar. Now, I'm going to use a real life example. This, however, was a quite elderly disabled individual who'd been disabled his whole life. In that case, I represented one of the guardians. The guardians are not playing nice together. And in that situation, the guardian said, well, I've got all this money in a special needs trust. I'm going to spend all of this money and then get them back on Medicaid. And both I and the court visitor immediately like, Your Honor, that's not what is required here. This is somebody who is not even educated themselves of the basics of their job. They do not need to use the money in the special needs trust to qualify for Medicaid. That is something in a special needs trust that can be set aside. So instead of being educated on what their requirements are, I think they're just operating from their gut feelings. But that was one that really, really jumped out to me. And that to me would be a breach of your conservatorship duty. Now, moving to 25, this is a lot of the problems under the new law. There are a crazy amount of notice requirements, and many of these notice requirements are not relevant to the developmentally disabled population. I'm not going to go through what each individual one is, but basically every time you take an action, you've got to provide information to the individual. That sometimes can be a problem because the individual doesn't understand, or the individual gets crazy ideas in their head. I represent a certified professional guardian. That's a professional guardian. And I have an individual who they are guardianship for who reports my client dead about 6 or 8 times a year. So he has enough capacity to understand that, but he doesn't have enough capacity to handle his money. But he loves to call up Social Security and report my client dead. And then we've got to fix that now. So that just shows that even when you're the guardian or the conservator, you've got some problems. I have seen situations whereby providing the individual under guardianship with documents is a terrible thing because now they think people are stealing money, or though they didn't spend that money, where's their money going? So let's switch to 26, and this is where I'm going to do a little bit more editorializing. Who needs a guardianship? So number one, and it's not on this slide, but anybody who files a guardianship is on the hook for the fees and costs associated if they file it without due diligence. I have never been successful in that situation of getting the money back, but there have been guardianships that I think come really close to that. An example would be somebody goes and files a guardianship against me. I'm trying to think of a good reason why you'd file a guardianship against me. You file a guardianship against me. Oh, here, let's use this. We find cat lady. You file a guardianship against somebody because they have too many cats. Well, that's not in the statute. It's something that's required. And then you go through the whole process. They find they're competent. They just have too many cats. Then you could be on the hook. So that's the first thing I always like to tell everybody. You file that guardianship. Once you sign that petition, your money's on the line. The number 2 requirement is there is no legal requirement to have a guardianship just because you turn 18. And I don't care what the school says. I don't care what DSHS or DDA say. There is no legal requirement to have one. It is not automatic. They turn 18, you need a guardianship. There are many disabled who live without the benefit of guardianship. And it gets to something I've said before. It may be counterintuitive, but the more disabled you have as an individual, they may less likely need a guardianship. So let's use the party that is so disabled they cannot go anywhere alone. I don't see them working. I don't see how they can be financially abused. They're not going. Now, this is about me, so this is me living in the 90s. They're not going to go to the mall and go to that kiosk in the middle of the mall and sign up for, siding of their house. They can't do any of those things. So they may not need a guardianship because mom and dad or mom or dad are always there, or a caregiver is always there. A guardianship does act a little bit like an insurance policy, but it's an insurance policy with a lot of caveats. And I kind of cross my fingers here. You've got to deal with the court, and you're reporting with the court. I think we'll talk about this later, but your reporting requirements generally are 1 year out, and if the court grants it, then every 3 years. So you're spending money to report to the court what has happened. If it's just a guardianship only, that's not overly hard. But if it's a conservatorship, you have to show where all the finances went. And that can be a real pain in the butt. So that is what I like to say to people is don't think you need a guardianship just because. So let's go to 27 and some considerations. Number 1, I always ask is, why are you doing it now? Why is it today? And I'm going to pick on the individuals who come to me and say, well, my 26-year-old needs a guardianship. They've been disabled since they were 3. Why are you doing it today? And the reason may be the doctors are giving me a hard time, or somebody told me I need to do it. Well, I hate the second one, and the first one we'll talk about in a little bit, but I don't completely agree that you need a guardianship to make medical decisions for your child. In fact, we have a statute that says otherwise. The problem is hospitals, facilities are completely not being rational, in my opinion, about how they look at this. I think some of the confusion is HIPAA law that exists. It's a federal law. And there's all these issues between does state law control or does federal law control? My personal opinion is if you read the Constitution, the states make decisions unless it's specifically granted to the federal government. I don't think the federal government even agrees with that anymore, but hey, that's there. The other thing to look at, this does take time. This does cost money. Is there an alternative? It needs to be a well thought out decision. The other one I will say, and this applies more to elders than maybe some of our disabled kiddos, but how will the loss of autonomy affect the respondent? I don't think my daughter would realize one way or another if she had a guardian, but I certainly have individuals who've been paying their bills for 80 years and then they said, we're taking that away from you because you can't do it. No, you can't drive anymore. Even sometimes that's the right thing to do. And that is going to lose some of the elders with a loss of autonomies. Now, slide 28, common reasons for guardianship. The big one, number one, medical and dental care. That is really where it kind of rubber meets the road for a lot of our people. The other place is when you have contact with the legal system, you're a victim or a perpetrator. I just was at Tacoma Pro Bono. I volunteer, and that can be a very depressing circumstance because you have people coming in saying, you know, my son's living on the street. He's got terrible PTSD. He's not taking his meds and he's taking drugs and I want a guardianship. And it always hurts me to say this is that may be valid for a guardianship, but the judge will not be keeping them every time they try to pop a pill or every time they shoot up. And there's only so much you can do. Couple other reasons is they may need a passport, though I know people who get passports all the time without a guardian. One that I've seen is they're moving to a group home or an adult family home, and the facility requires it. I've seen that happen. I think that's, again, a little misguided, but I also see where the facility is looking. There is a demonstrated harm. I've been talking about guardianships, but if you have the disabled individual who is going to go to the mall and sign up for siding to buy aluminum siding for the house they don't own, or going to give all their money away, or I remember there was a young lady I met who, if she went to McDonald's, if she passed them a 20 and she had $5 for her meal, she wouldn't even think about change. She would just walk away. Maybe those are some things that we might need a guardianship for. My general feeling with this is you're looking at guardianship and conservatorship for the more functional of our disabled kiddos because they're the ones who are out in the community more often. So if you've got somebody who's working or got somebody who's easily, I don't want to say manipulated, maybe influenced, those are reasons you might want to look at it. Okay, number 29. Can medical providers speak with non-guardians and parents of adult children? Well, yes, they can. And if there's one thing you take away from this is go on the internet, put in RCW 770.065. It's in the materials. That's 7.70.065. That is our informed consent law that says if you have somebody who is disabled who doesn't otherwise have documentation, they can make the decisions for them. Now, I will then contradict what I say. Children's Hospital will not accept that whatsoever. So if you have somebody who's over 18 at Children's Hospital, they're not sharing anything. I hear some of the colleges and universities are doing that as well. And let's go over to number 30. Can schools talk about IEPs of adult children? Well, that gets to be a little bit difficult. Yes, the answer is yes. There are ways to do it. And parents do retain the rights to access records of student who's a dependent. That is under the US code. I'm not going to read it out to you because it's long. I actually think it almost looks like 1, 2, 3, but it's not 1, 2, 3, 4, it's 1, 2, 3, 2. There is also, can medical providers, again, talk to the children, provide informed consent? That is 770.065. Where things get weird with IEPs is what some of the WAC and some of the things say is states are required, this is slide 31, by the way, under the federal idea, they are required to provide ways to do that. We have done that in Washington. It's slide 32. It's WAC 392-172A-05135, section 5. Of course, lawyers wrote these because nobody else would use that as a number. Students over the age of 18 who have not been determined incapacitated may provide informed consent to the parents based upon statements from 2 medical professionals. Now, I do not love this for 2 reasons. One, you got to have 2 medical professionals who will provide this information. And 2, it has to be renewed yearly. So it's a pain in the butt, but it does allow. I think, in my opinion, the reason they did the yearly renewed is, one, we want to protect everybody, but also, I wonder if the legislature understands that kids can stay in school till 21. I kind of wonder that sometimes. One big change under the new law is the statute, and this is slide 33, does allow a guardian to establish dwelling for an individual. That was not allowed under the old rules. So you can provide that. I think that that was a no-brainer. I think often that's what guardians are doing, but that does allow. All right, slide 34. What can't a guardian do? There are a lot of misperceptions about what a guardian to do, and you need to be limit. The big one, there is a ton of statutory language, slide 35, about how much a guardian can restrict contact with people. There is a process that if you have somebody who is, for lack of kind of the popular term, toxic to the individual, you can limit them, but that has to be providing a lot of evidence. It's not, we don't like so-and-so, so they just can't come see them. There's got to be kind of some shown harm. There's also an individual, and this is slide 36, has a right to refuse psychotic medicine. So you can't just force pills down their stomach. One of the cool things under the new law is slide 37, which is modification. So you now can modify and terminate a guardianship. We never had any clear direction to how to do that. We were all grappling. And one of the things a lot of us have been doing over the last little couple years is getting rid of guardianships for either children who have graduated the guardianship. So at 18, they needed the help, but they were just a little development delayed and took them longer. And now, you know, at 30, they're where they should have been at 18. Those are awesome things. I love doing those, to be able to say, okay, we're giving you some more rights. I remember I had a gentleman who would bop between his mom and dad's house because it's who irritated him the most on any given day. Like, dad wouldn't let me have McDonald's for dinner, so I'm going to move with mom. Dad was very patient with that. Mom was very patient with that. But we were able to graduate him out and give him a little more independence. I hope he's not eating McDonald's every day, but I also wouldn't put it past him. The court has broad authority to do anything it believes in the best interest of the person subjected to guardianship, and that's where it gets really hard here. Our courts in Pierce County are awesome, to be totally honest. However, that doesn't mean you're always going to get the answer you look for. And there's 2 things that I tell everybody. Anybody can sue anybody for anything. Doesn't mean they're going to win, but they can do it. And 2, anytime you're before a court, you cannot guarantee an outcome. So I had a situation where on the same day between 2 different judges, I and a friend attorney were basically dealing with 2 cases that had very similar facts. Now, in my case, I was going to say, I think there's maybe slightly more, I don't want to say abuse, but there's slightly more mismanagement of the guardianship in my case than the other case. In one, they removed the guardian, and in mine, they just said, you guys got to keep working together. I don't really think that was the same, but that shows kind of the power of the court visitor. In my opinion, the court visitor in the other case did a better job than the court visitor in my case. So I like to warn people, just because you go before the court doesn't mean you're going to get what you want, and be prepared for that. It can be really interesting. So we're going to slide 38. Modification of a guardianship, it's a major term. It used to be one seeking change had to prove it was not necessary. Now you must prove it is necessary. So you basically need to go through the guardianship again. This may sound minor, but it's actually a really big change. So one of the situations that we have is you have somebody who is under guardianship, but they've gotten to the point that they can execute a lesser restrictive alternative. And the big lesser restrictive alternative, and I know Beth Ann does these through PC2, is powers of attorney. And one of the things that I think is amazing is if there's any way, and you have to wait till they're 18. Don't do it before because they're not legally competent to do that. Um, you're going to have a situation where the child may not have been able to do it at a certain time, but now maybe can execute that power of attorney. They've gotten more skills, they've done better. That's a really useful tool. I also think it is worth the fee to sit down with an attorney and evaluate, can the child make a power of attorney when they turn 18? I've had it go both ways. I have met with people that we've done it. I have met with people that they couldn't. It is also a little bit depending on the circumstances. If you've got someone who has some of that psychosis, if you meet with them in a moment of clarity, they might be able to sign it. 3 days later, they might think they live on Mars. That's okay. As long as at the time the document is witnessed, they had legal capacity, we're okay. So that is a major thing to look into if you have somebody. And again, I said they don't necessarily need to be verbal. If they can use assisted technology or point. I once had a gentleman who could point, who do you want to be your guardian over there? Or what was so funny is the guardian wasn't even in a room and he pointed like they had just left, and sort of you could get he understood what was going on but couldn't verbalize it. Going off topic for a second, this is what frustrates me with my daughter so much is you can tell there's something she's trying to get out and she can't say it. It just that's what kills me the most, is knowing there's something she wants to say and she can't figure out the words or verbalize the words or get what's in her brain out. That's one of the things I hate most about autism. Okay, so we're going to switch. We'll go to slide 39. Transferring a guardianship, it can be done. There is a process to do it. I'm not going to get into it a whole lot. And sometimes you have to do 2 hearings, 1 in each state. Sometimes you can just leave the guardian in place in another state. Depends on circumstances. Now, I've jumped the gun a little bit, and now we go to slide 40. There are alternatives to guardianship. The big one I've already talked about is powers of attorney. If you can do those, that's a great thing. I've also talked a little about supported decision making. So you're not going to make a big purchase over $50 without talking to your mom or to your sister. You're going to abide by these rules. And this, to me, is just the creativity of the individual people who are involved. So that is something that gives a lot of leeway. And I don't think I honestly have explored it as much as I can. I think that there are a lot of opportunities, and as time goes on, we'll just see that. Now, I had said early on, we have 2 kinds of guardianship. We have full and limited. Full is, I took away all your rights. I have, as guardian and conservator, the right to do everything for you now. But that's not necessarily something for everybody. So let's go back to the woman I talked about before, who was going into the mall and signing off and buying things she didn't need. Well, there's a possibility we could do a limited guardianship. We could give her the ability to do things, but the only right we take away from her is her right to contract. And that's a possibility. I will talk about special needs trusts a whole lot more in the future at another one of these, but that is another tool that can be used. One I did not list here is the ABLE account, which is one of the greatest things that happened in kind of disability law in the last 10 years. That is an account that allows you to put small amounts of money away for your disabled individual without having to spend all the money to go set up a special needs trust and all the rigmarole and all the attorney fees. So if you have the situation that I know has probably happened to somebody in the room, you apply for Social Security for your child. Social Security takes forever. They then send you a check for $20,000. That was all the money owed. And then they said, by the way, you're off benefits because you're over what you're allowed to have. That is where the ABLE account's awesome. You can't put the whole 20 in, but you can put 18,000 in there and get them down to their 2,000. Now the problem is when you got $23,000, how do you get there? But that's something we'll talk about in the future. But the ABLE account is amazing. You can set them up online. You don't need it. They're a wonderful tool for small amounts of money that the individual has. Now, I'm going to go a little off topic here and kind of ruin something I'll talk about just because I get this question a lot. Special needs trust is both a thing and not a thing. There are basically two kinds of special needs trusts. One is money of the individual, which is the person, the person became disabled in a lawsuit and they got $100,000 from the car accident. That is their money. Grandma makes terrible choice and leaves $100,000 to your disabled child. You're probably going to have to do basically a special needs trust because that money now belongs to the child. But if for a lot of us, we're saying, well, when I die, I want my money to go to my child. That is a third party special needs trust, and that is a different animal. So I just want to tell everybody, if you are looking to do your own estate planning, which is very important, and you want to leave money to your disabled child, look at doing what's called a third party special needs trust. One of the things I used to see all the time and makes me very, very nervous is the people have two children, one disabled, one not. Well, I'll leave it all to my other daughter. She'll take care of her. Well, she might, but she has no legal requirement to do that. And that always makes me very, very nervous. The last alternative is do nothing. So one of the things that I did not talk about before is you have your disabled child. We talked about they get Social Security. Well, as part of that process, you can name what's called a representative payee. So for a lot of our disabled, and I keep calling them kiddos, but they're adults, so disabled adults, they are getting some money from Social Security, but you can do a rep payee for that. You can also do it through the VA if there's any VA benefits floating around out there. So they don't need a conservator. In fact, I would say for a lot of disabled parties over 18, you don't need a conservator because there's just no money there. If they're working, maybe. It depends how much they make, but a lot of people are just working really part-time, not as much. And then the consent of healthcare statutes. So if you've got the kid who is getting Social Security, lives basically is bedridden, and the only time they go out is with you, I would try to do nothing. And as long as the medical professionals don't screw things up, you're in good shape. So I'm now going to go to slide 41. With a power of attorney, there are a few things you cannot do in a power of attorney. I would never put for a disabled individual that they can change a will or change beneficiary designations. Like, I think that's just, it's going too far. But the cool thing about a power of attorney is it's supplemental. It's not taking away their rights. It's adding somebody who can look over their shoulder. So where I see that all the time is you've got the somewhat disabled child who is managing their own money, but it's always good to have mom and dad take a look to make sure they're not, spending it all on McDonald's. Or I once had a kid, we're pretty sure he spent $1,000 on candy. Not sure how we could ever account for it. It was really hard because this is under the old law. And we couldn't account because he was given a debit card, which he shouldn't have under a guardianship. And he was using it, and we think he was buying candy and things like that. So it was really hard. Like, we knew where he spent the money. There was a lot of money being spent at Walmart. It was pretty crazy, and Target. So, but we couldn't figure out what it was for. And last statement here, it usually avoids the need for a guardianship. That is a true statement. Sometimes even with a power of attorney, you need a guardianship because sometimes what happens is you have individuals who are fighting and you have dueling power of attorneys, and it's just a freaking nightmare. I see guardianships that get filed because two siblings are fighting over mom, and that can just be kind of a nightmare with that. Okay, going on to 42. As I said, they must have sufficient capacity to understand and communicate what it means to have someone help them. And that is, a simple question. Who would you like to help? And if they say mommy or daddy, hey, maybe they do have capacity. And it's a little more complicated than that, but that's a helpful thing. I've talked a little bit about supported decision making. Basically, in this slide 43, this is a written agreement. I'm a little unclear what advantages it has over a power of attorney, but maybe it's a supplement to the power of attorney. And as I said before, maybe for the rule follower kids, it's really good to have, because maybe just laying out the rules saying you can't do this on paper on court letterhead is enough. And that's really cool when it works. I'm not going to say it's going to work because, if the number one on there, don't do drugs, that might work, that might not work, because I think that's a lot of what we use it. I think it's best, and this is now moving on to slide 44, with high functioning individuals, especially kids who might be suspicious of a power of attorney. And I think you got to do it together. But we'll see. And I think for most persons with a development disability, I'm not sure it works. But again, maybe for those rule follower kids, it does. 45 is limited guardianship. The court can tailor guardianships. This is very much favored by the legislature and quite honestly not used enough. Now, this is where I get on my kind of my soapbox of confusion. We see these words limited and full guardian thrown around all the time. I'm an attorney and I'm never quite sure what the difference is. Like there is some specific things when you file a guardianship. If you revoke the right to vote or you revoke the right to marry, you've got to have some additional findings legally in both the order and in the court visitor report. I don't think even if you leave those, that's limited, but some people argue it is. Like it's kind of an amorphous situation of what you're granting. But if you have a true limited guardianship where you say, okay, all I am going to do is help this individual with medical decisions, I'm going to leave all their other rights intact. That could be a very good limited guardianship. And I think when you have the delayed developed kiddo who is you're struggling with the facility, that might be a lesser restrictive alternative. Say, all I want to do is limit the guardianship to talk to the doctors. And I think that would be a good way to do it. I think it is not used enough. Flipping over to 46, again, reasons need to be provided. The scariest one to me is the possess a license to drive. I've had nightmares, and I'm not kidding, where I wake up because somebody gave, I remember this one, they gave my daughter a car, a Ford Mustang, and she was driving around and crashed in 5 minutes. I joke with her all the time, anytime we're going anywhere, are you going to drive? And she says no. So I don't think there's any reality of her wanting to drive, but we do have some kids who want to drive. What I've listed here, and this now goes to 47, is different things that you can limit. Big one there is managing money sometimes. The enter into contract is the one that I worry about the most, because if you do have kind of the ne'er-do-wells or taking a financial exploitation of an individual, I think that's where it becomes a problem. To make a revocable will, I think gets into stuff I don't want to get into, but that can be a problem as well. After just being at Tacoma pro bono, it's amazing how many people magically take the disabled adult to the will and have the will changed quickly before death so that they get everything. That's always very interesting. Going over to 48, what I see less need for conservators under the new law than there used to be. I've already kind of talked about that, as rep pay is a wonderful tool. You don't need a conservator if your kid's not making any money. And I don't think you need to be, I intellectually don't think you should be granted a conservatorship if you just say to the court, well, they might work someday. Well, that's not an emergency and it's not now. So the court might, and this does probably differ from county to county, how everybody looks at this. I do almost all my practice in Pierce County, so I'm a little out of touch of what the other counties do and see and what's most common at this point. But it wouldn't surprise me that King County does things a little bit different. The big thing here with limited guardianships and the agreements is be creative. There's a lot of opportunity here. Don't be rote. And the big thing I want parents to take away is this is not a simple question that everybody, teachers. So in full disclosure, and I don't love that this is going out, but in my own life, that's a little bit of the stress, is my former spouse is being told, you need a guardianship, you need a guardianship. And I'm saying, you don't. I do this for a living. And of course, she apparently sees the teachers and the DSHS people as bigger authorities than me. And one of my goals in life is try to educate DSHS, DDA, Tacoma Public Schools that this is not an automatic thing. And you're actually violating the law if you just say, turn 18, go get a guardianship. That's not the way this was done. Again, there needs to be a harm. All right, I'm now going to 49. I talked a little bit about special needs trusts. I want to basically say as I said, there's two kinds. There's what's called a third-party special needs trust, and there is a special needs trust with the money of the individual. Third party is grandma's leaving some money, you're leaving some money, have a special needs trust for your child so that money goes in there. That does not have a payback provision with the state. as opposed to what's a true special needs trust, which is called a D4A trust, that has a payback provision. So when the individual dies, if there's any money in that trust, that has to go back to the state. Whereas if you do it in your own will or trust and you set your own thing up and it's a third party, that can go to the other kids. Um, Special needs trust used to be our only tool when it came to planning, but as I said, ABLE accounts allow that to happen. Now I'm going to go to 50. We talked about the D4A trust. This is a complex area of the law. This is not something you should do self-help. This is not something you should be doing off the internet. Like, this is complicated stuff and there's a lot of ability to screw up. And an example was the story I told before, was the individual didn't even understand what the special needs trust was for. And in this case, this was money that was left by a parent who had passed away, and they literally were going to spend this money down. And personally, I thought that alone was a breach of their fiduciary duty, but I represent the other side. So now we'll go back to ABLE, and I will see, and this is slide 51, and this is my first mistake. I have lied to you. I am sorry. It is restricted to 18,000 in 2024 because it is a new year. So I apparently, when I went through my thing, didn't catch that. So I apologize for that. But you can now put up to 18,000 a year for ABLE. This is a useful tool. It's a great way to shelter small amounts of money. There is a link there. There is also, it's stable, I think, which is Washington State ABLE. If you just search Washington State ABLE, it's run through the government and it is there. We've already talked about slide 52. That's representative payee. That is where there's a system set up that you receive money on behalf of an individual. That is great for Social Security. I'm going to reach down here and pet the dog for a second because she's going crazy. This is a useful tool for our individuals, and it's pretty cheap and it's pretty easy, and you don't need to pay an attorney to do it. You just fill out some forms with Social Security, and now you're the rep payee for your kid. You do have, again, you're a fiduciary, you're managing that money, you have to report to Social Security. They're very unpredictable about when they're going to do that. It's not like a guardianship where you're going to have an annual review in 1 year and then every 3 years. With Social Security, you never know when they're going to call you up and say, we want to do this. All of these programs are really set up for annual reviews, but in reality, they don't happen. I've had some people who've never done an annual review. I've had some people who've done them quite often. So that is a good thing to look at. One of the situations I've had is I've gotten rid of 2 conservatorships this year because we just did rep payees, because there was no need to have a conservatorship and have all that cost and have all those reporting requirements. And even on a Medicaid case, we were still spending $1,200-$1,400 every couple of years doing the annual reports, and that is less than usually what I charge at private pay. So when you have a guardianship, it's going to cost quite a few $1,000s to open it. You're going to have an annual report a year in. That's a few $1,000s, and every 3 years. If it's just a guardianship without a conservatorship, that's probably something you can do on your own if you're pretty smart. With a conservatorship, I still think you need help because you got to provide a full accounting of basically where every penny went, which can be hard. Okay, let's go to 53. I keep repeating this, but 770-065, such a big deal. This authority, and what I wish I'd put in here, instead of in many cases authority is sufficient and no guardianship needed, is in many cases this authority should be sufficient and guardianship isn't needed. But as I said, I have run into problems with facilities. Again, I don't want to throw anybody under the bus, but many, many years ago, I was talking to a head of HIPAA, which is the federal health privacy law, with a large local teaching hospital program. And I'd always suspected that HIPAA is used because a lot of people didn't want to do any work. And this person volunteered. I hate when I overhear people in my facility using HIPAA as an excuse to do nothing. And I'm just like, you said it, not me. I knew it. I knew it. Come on. This is the way it goes. I think HIPAA is used as a crutch for a lot of people. Instead of doing what's in the best interest in the individual. And I kind of operate, and I hope you've got this by now, there are the legal requirements, but we're also looking out for these people. One of my biggest fears, and I do not have a solution to this, and I'm sure you share it, is when something happens to my spouse and I, or my ex-spouse and I, who's going to take care of our daughter? And it's, and even including her biological dad, we're all in our 50s. We're not getting any younger. She's 19. There's going to be time when none of us are here to help her out. And that's really scary. And I don't think as a society we've really provided for that. Okay, let's flip over to 54 and talk about who can be a guardian. There are not statutory requirements. The big thing is you can probably not be a felon. That's the big one. If you're a felon, they're probably not going to appoint you. You do have to disclose any criminal or bankrupt history. The bankruptcy is an interesting one. The court has the ultimate kind of decision with that. But when I've had them disclosed, the court hasn't given us a real hard time. When they're not disclosed and the court finds them out, that is a real problem. The court has a right to review the criminal and bankruptcy history. And I'm going to tell you, if you got a felony, you're probably in trouble. If you've got a felony for fraud, I'm going to tell you, you're going to have a real problem. Can a guardian be paid? Yes, this is slide 55. They can be paid. If it's a professional guardian, they deserve to be paid. Family members, most of my family members don't ask for payment, but sometimes in lower income, there are ways to be paid through the through DDA, DSHS. And if that's something that can be done, you can be paid. I get a little frustrated when you have quite wealthy people who are charging money for from their disabled individual just to get more money in their pocket. But there can be reasons to do it. Because if you're getting this Social Security money, you got to spend it because you can't go over $2,000. So maybe you charge them rent. Maybe you do other things like that. But again, case by case, take a look at what's going on. If they have no income, I don't know why you're charging them. You're not going to get paid. And I think the courts are very, very appreciative of individuals who take care of their kids and don't charge. I think the courts really appreciate that. And I kind of looked at that. Okay. What is the liability of being a guardian? You should all worry about liability. I worry about liability a lot. You are a fiduciary, which means you are in the shoes of the individual. And I'm again going to use a real life example. As a fiduciary, as a conservator, you should have a conservatorship account. You can't have the money in your name and the individual's name or your name alone. You cannot do that. That is not okay. The court retains jurisdiction. You are not as guardian liable for the debts of the individual unless you somehow cause those debts. But be aware of that. You are not obligated to provide housing to the individual, and the court always looks at reasonableness. I do see a lot of people who are charging their kids rent. I have no problem with that if there's money coming in, and often it's necessary simply because you got to spend that Social Security somehow because you don't want to lose it. All right, let's go to 57. And I wish I had entitled this Bonding, Not James Bond. There is a requirement if the assets are over $3,000 that the court order a bond. That's going to be up to the judge. It's going to be reviewed. And I have had people who have been disqualified of being a conservator because they're not bondable. So they have bad credit. They have issues in the past and they're not able to be bonded, or no credit. That's another one. The court will look at the income as well as the assets. And I am a big fan of bonds that cover, if they run off with the money, that people can be paid back. This also happens in estates. I see a little more people ripping off people in estates, but it absolutely happens in guardianships as well. If you want to be scared, and I'm going to put up my hand and swear I've never seen this movie, but there was once a Netflix movie about a bad guardian, professional guardian, who was ripping off old people called We Care a Lot. Everybody told me it was really good. I can't watch it. I do this for a living. I don't want to see any more pain. Now, let's go to slide 58. Who pays the guardian? Usually it's going to be from the respondent's money if there is money in there. You could receive services from DSHS, but otherwise often there is not money to pay the guardian and the attorney. And I will say, as attorney, I like to get paid. I do this for a living, but I've done a few of these where I haven't got paid, and it's just part of the knowledge. I also sometimes take on cases that I shouldn't if I want to get paid because I feel for the individuals. Going to the next slide, 59. Your guardian, you need to keep track of everything. Keep track of your time, fraction hours. I'm used to billing my time. I do everything in 0.6 extra, 0.6. No, that's not right. 0.2, 0.1 is 6 minutes. So I split my hour into tens. So every 6 minutes, that's how I bill. You got to get used to it. You got to keep records. This is what'll get you in trouble so quickly with the court is if you can't provide records, the court might say, we're going to remove you. You've not done your job. So keep records if you ever end up as a guardian. Okay, number 60. When you file the petition for guardianship, I should have put that one first. There is a filing fee in Pierce County, and it's actually I put $241.50, but that shows I pay everything on my firm by credit card. It's actually $240. The $150 is the credit card fee. That filing fee is in place. If you have under $3,000 in assets, you can go to court and get that waived, but you have to go to court to do that. Once you file the petition, you've got to give notice to the court visitor. So what will happen, and let's do this. You decide, okay, I'm going to go file guardianship. What do? Well, you go to the county city building, and you go find the Superior Court, and you go down to the clerk's office, and there is a room there called Commissioner Services, and you talk to them, and you walk in, and you got to have your petition all filled out and your order and all that good stuff. The law library can help you with that if you're doing it on your own. You walk in with all your paperwork filled out. And if you're low income, you can go to Tacoma Pro Bono. And on the third Thursday of the month, we do a guardianship clinic there. You go in, you take your paperwork, you go to Commissioner Services, you say, I want to go to ex parte court. It means, actually, I don't off the top of my head remember what ex parte is, but it's walk-in court basically. You pay your fee or you get your fee waived. You get a court visitor appointed. If they appoint me, I don't know if I know who is all on the list, so it may not be a conflict, but if I've talked to you, I can't be the visitor. And then you must serve the respondent and the court visitor with both the petition, and there's a specific notice that's required. And actually by statute, though we don't do this much in Pierce County, you're supposed to tell them when the hearing is. That often is done separate. And then a hearing must be held within 60 days. If that you exceed the 60 days, you have to have a motion for more time. Sometimes it takes longer than 60 days. It's not unusual. It takes longer than 60 days, but there's some procedure that needs to be done. When you are waiting for your hearing, you've got to go onto Washington courts and take the guardianship training, and you have to file your certificate. There are some forms you have to file, a declaration of a guardian. That's actually a Pierce County only thing. A declaration that says you're not a criminal and you're not bankrupt or have an active bankruptcy. You could say I had one in 1982. It doesn't apply anymore. And you've got to accept as guardian. So there's a lot of paperwork that needs to be done. And that's often the stuff that the pro se individuals struggle with. So going to the next slide, let's talk about court visitors. So I am both an attorney and I'm a court visitor. One of the things that is somewhat disconcerting in Pierce County is our guardianship bar is pretty small. So sometimes it looks like we just switch around in each other's cases. And for the appearance of having some propriety, I try to set my cases when I'm visitor on one day and when I'm petitioner or respondent attorney or something like that on a different day. So it doesn't look like I'm just switching hats. And sometimes we literally have hearings where the same three attorneys are involved in two different hearings because there's so few of us. What the visitor does is there's a list in each county. I think in Pierce now we had a really small list. I think we were down to like 8 at one point, and I think we're hitting close to 20. So that's nice. Doesn't have to be attorneys. It's often easier if they're an attorney, but they don't have to be an attorney. They are not your free legal help. Their job is basically they're an investigator. The court can't send out an investigator, so that's what the court visitor does. They arrange the medical report that has to be dated by a doctor or a RNP who has seen them within 30 days. And the visitor has to file a report 15 days prior to the hearing. We switch to the next slide. Here are some of the questions. Does this person need a guardianship or conservatorship? Are there less restrictive alternatives? Are the proposed guardians qualified? Are they the most appropriate people? Going to the next slide, you explain to the respondent what the petition means. You ask if they want an attorney. Sometimes they say yes, sometimes they say no. You ask if they want a jury trial, and you look at other documents. I'm going to be doing one of these meetings tomorrow. One of the things I want to look at is the financial documents because I want to see if the person who moved in is taking money. Who appoints the guardian? That is the judge or the commissioner. In Pierce County, it is almost always a commissioner. I've seen this trip up attorneys from King County all the time. They try to set it on a judge's calendar, and the judge does not make that decision unless we go to trial, that it will be before a judge. But if it's an uncontested or the individual just has no capacity, it's going to be before the commissioner. A commissioner is basically a judge who's not a judge. They're basically the same, only they get reviewed by the judge. The judge will appoint the guardian if they think it is necessary. Going to the next slide, as I already said, we must have the hearing within 60 days, but you can extend it. You can get the guardianship dismissed for lack of timeliness. It can be continued for good cause. And the most reason it gets continued is the medical report. Getting doctors to act sometimes can be interesting, to say the least. When the hearing is over and the guardian or conservator has been appointed, there are some things you need to do right away. You need to do your acceptance, though often the court's looking for that before you even do it. I struggle with that, but all mine are in before the hearing because that's what the court wants to see. I don't know how you can accept when you're not appointed, but whatever. You have to file a bond if you have over $3,000 in assets, and then you get letters of guardianship or letters of conservatorship or letters of both. They're on nice blue paper. That's what gives you all your authority. The slide has jumped ahead. That's good. You also have a 14-day notice, which is a copy of the order. And you have a 30-day notice, which is a specific form about notice of rights and their ability to contest the guardianship. As I said, for a lot of people, this doesn't matter because they just don't have the capacity to understand, but these are still all required. All right, let's go to slide 68. This is where it gets a little bit complicated. Within 3 months of appointment, you need to file a guardianship plan, and there is a hearing required on the plan. This is one of the weird parts of the statute. When you file the guardianship plan, and if you've got a conservatorship, you've got to do an inventory. You have to file it within the 90 days, but you can't have the hearing for 30 days. It's the only one that specifically says there's a period of time you can't have the hearing. And I don't know why it's 30 because most of our court rules are 15 days. So legislature just made up 30 days. You have to give everybody notice, as I said, 14 days ahead of time. I use 15 because I like to be ahead of schedule. Now we'll go back to slide 69, and this is the annual reporting. As I've said, it's often set for 1 year, and then you can ask for 3 years cycle. One of the things that I have not told you all is almost all these forms are on Washington Courts. I think it's washingtoncourts.gov, but if you throw Washington Courts into Google, all of these forms are available. If you are not living with the individual, and this is now slide 70, you have to say how often you visit it. There are requirements of who you have to notice, sometimes ridiculously, and then you have a hearing that's set by the court and you got to give notice moving forward. So do you need an attorney? Well, I'm an attorney, so I'm going to say yes. Give me lots of money and I'll do your case. No, I'm kidding. It does depend. I see people who do these and do them well. I see people who do them and struggle. There are a lot of requirements. My feeling, and I'm not just saying this because of my bias, what I am always concerned about whenever there's a conservatorship, I think you kind of need an attorney because you're dealing with money and you can make a lot of mistakes. If it's just a guardianship and it's a disabled child and they live home with you, you can probably do it on your own. Just make sure you meet all your requirements because I see that happening all the time. Like I had mentioned, the person who contacted me, they had not provided any of the immediate stuff. I'm not sure they ever gave the notice, all those kind of things. So let's go to 72. Cost of a guardianship. With an attorney, this is going to cost quite a few $1,000s. Without an attorney, you've not, the party has under $3,000, it could be, nothing. The court visitors are either paid privately if the party has over $3,000, or if they have no money, they're paid by the county. As a court visitor, I always love private pay cases because I get paid my normal hourly rate other than my discounted rate. There is, as I said, a filing fee. The annual reporting also exists. And then the big question is, where does this money come from? Often the parents are footing the bill because the individual has no money. Or you try to save up the money to pay me. I've got a client actually who pays me every time the account gets over $2,000, sends me a check. So I get paid. Like I don't have a hearing, I think, for 2.5 years in this case, and they send me small amounts of money anytime they get over because they're trying to keep that account under the 2,000. All right, next slide. I've already talked about this, but your will and your estate planning also factors into all of this. If you do have money that is going to go to your disabled child, you want a third party special needs trust. You do not want a will that says everything to my two children equally, because that's going to lose your child benefits and they can't manage that money, and that's going to be a big mess. I think a lot of us think about that. I also understand this is sometimes a moot question, because when any extra money you have is going to take care of your kid, going to take care and help them out. The reason I put representative pay, we've talked a lot about it, but again, it's just something to think about. I think for all of us who have disabled children who are receiving Social Security, that you should be the representative payee, whoever that is. Okay, 74. And I'm just going to say this. Many individuals with significant disabilities live their whole life without a guardian. Others may need protection when they turn 18 and will be harmed by a delay. Others you may defer until it becomes a problem. That is my ultimate depends. It is not automatic. It's the big thing I want to drill into anybody. It is not like people say, well, they turn 18, you need to go get it. In fact, I'm a little disappointed by our legislature. I understand we're going to have a change in guardianship law that you're going to be able to apply for a guardianship before they turn 18. So when they're, 17 and, 60 months away from the 18th birthday. I have some severe due process concerns with that, which is, how can you have a hearing for somebody who you've done this whole process without giving them access to an attorney? And once they turn 18, they're an individual. So it almost, to me, seems silly. I have never seen a situation where somebody is so harmed that they can't wait until they're 18 to file. They can take 60 days, as I said, but that's not a terrible situation. As I said, there are many reasons why a guardian may be appropriate. I'm in slide 75. But each individual circumstances are different. And in fact, under Washington law, you must evaluate individually. Contact your legal advisor and make decisions. Please do not just do this because the school said it, or DDA said it, or DSHS said it, or the guy at the gas station said it. Those are not reasonable reasons. These are things that need to be evaluated by individuals. And then the last slide, slide 76, is just some random things. One of the things that I did is the guardianship forms are on there. It's www.courts.wa.gov, and then there's a forms section. There's some other things that are helpful that you can take a look at there. It does have the link to the RCWs. I should have these saved, but I just write, like, I want to look at 11-130-060. I just write RCW 11-130-060 into Google and it comes up. So that is what I've prepared. Hopefully I've left everybody enough time for questions. I am happy to answer questions if there are any, including questions at our school. And
so James, what I'd like to do is then stop the recording so we can go to questions and invite everyone to bring we realize this is a lot of information.
Yes.
And the reason that we wanted to be able to do this in one shot without having questions interrupting is because we will be posting this information on our website for people who are not here tonight. So